there, welcome back. This is Insurance World TV, a channel dedicated to breaking down and making insurance information accessible and easy to understand to all our viewers. If you have not, please subscribe to our YouTube channel and follow us on our various social media platforms. Today we're taking a small detour into the realm of contract document wording and jargon to shed light on a clause that often leaves us scratching our heads: force majeure. But what exactly is force majeure? In the most literal sense, force majeure is a French term that translates to greater force in English. It is related to the concept of an act of God, an event for which no party can be held accountable, such as a hurricane or a tornado. In the world of legal contracts, force majeure refers to unforeseeable circumstances that prevent someone from fulfilling a contract. These circumstances are often beyond anyone's control and can include natural disasters, war, strikes, or other events that make it impossible or extremely difficult to fulfill contractual obligations. Force majeure clauses are commonly included in contracts to excuse parties from liability or performance obligations when such events occur. Well, imagine this. You've signed a contract to build a house, but a massive earthquake hits, delaying construction or forcing cancellation or abandonment of that contract altogether. That's force majeure. Force majeure, often called act of God, refers to unforeseeable circumstances that prevent someone from fulfilling a contract. These could include natural disasters, war, strikes, or other events beyond anyone's control. Here are some of the reasons why having a force majeure clause in contracts is important. 1. Risk management. A force majeure clause helps parties manage risks associated with unforeseen events beyond their control. It provides a mechanism to allocate risk between parties by specifying how certain events will be handled if they occur. 2. Protection from liability. Including a force majeure clause can protect parties from liability or penalties for non-performance in situations where performance is impossible or impractical due to events like natural disasters, wars, or pandemics. 3. Certainty and clarity. By defining force majeure events and their implications up front, the clause brings clarity and certainty to the contractual relationship. It reduces ambiguity and potential disputes by outlining the parties' rights and obligations in unforeseen circumstances. 4. Negotiating power. Parties can negotiate the terms of the force majeure clause to suit their specific needs and circumstances. This can include defining which events qualify as force majeure, notification requirements, and the consequences of invoking the clause. 5. Flexibility and adaptability. In a dynamic environment where unforeseen events are increasingly common, having a force majeure clause allows contracts to remain flexible and adaptable. Parties can respond to changing circumstances without necessarily breaching the contract. 6. Business continuity. For businesses, especially those operating in industries prone to disruptions, a force majeure clause ensures continuity of operations during challenging times. It provides a safety net to navigate through unexpected events without incurring undue financial or legal consequences. 7. Legal compliance. In some jurisdictions, certain contracts may be required by law to include force majeure clauses, particularly for government contracts or contracts involving regulated industries. Ensuring compliance with legal requirements is essential for avoiding potential legal challenges. 8. Peace of mind. Ultimately, having a well-drafted force majeure clause gives parties peace of mind, knowing that they have a mechanism in place to deal with unforeseen events that could otherwise jeopardize the contract and their business interests. In summary, the importance of including a force majeure clause in contracts cannot be overstated. It serves as a vital tool for managing risks, protecting parties' interests, and maintaining the integrity of contractual relationships in an unpredictable world. The application of force majeure typically occurs when one party to a contract is unable to fulfill their obligations due to unforeseeable circumstances beyond their control. Here's how it works. Contractual obligations. Parties enter into a contract with certain obligations. These could include delivering goods, providing services, or completing a project by a specific deadline. Unforeseeable event. A force majeure event occurs, such as a natural disaster, for example, earthquake, hurricane, political unrest, for example, war, civil unrest, or a pandemic, for example, COVID-19. These events are often beyond the control of either party and make it impossible or impractical to fulfill the contract. Invocation of Force Majeure Clause. If the contract includes a Force Majeure Clause, the affected party may invoke it. This clause typically excuses performance or delays performance for the duration of the force majeure event. Notification. The party invoking force majeure must usually notify the other party promptly, providing details of the event and how it impacts their ability to fulfill the contract. Mitigation. Both parties should take reasonable steps to mitigate the impact of the force majeure event. This might include finding alternative suppliers or solutions to minimize disruption. Consequences. Depending on the terms of the contract and applicable law, the consequences of a force majeure event vary. It could result in a temporary suspension of obligations, termination of the contract, or adjustments to deadlines and terms. Resolution. Once the force majeure event ends, parties typically resume their obligations under the contract. Any delays or modifications to the original terms may need to be negotiated and documented. Overall, the application of force majeure provides a mechanism for parties to deal with unforeseen and uncontrollable events that impact their ability to fulfill contractual obligations, helping to manage risks and minimize disputes. Now let's break it down further with some examples. Natural disasters. Picture this. A hurricane hits your area, shutting down roads and airports. Your flight gets canceled. Airlines often cite force majeure to avoid compensating passengers. Pandemics. The elephant in the room. We've all experienced the impact of COVID-19. Businesses worldwide invoked force majeure clauses to cope with lockdowns and supply chain disruptions. Political unrest. Imagine you're a supplier caught in the middle of a civil war. Your ability to deliver goods is compromised. Force majeure can protect you from penalties for breaching contracts. But here's the kicker. Not all contracts include force majeure clauses. It's crucial to read the fine print before signing anything. And remember, invoking force majeure isn't a get-out-of-jail-free card. It requires proof that the event genuinely prevented you from fulfilling your obligations. So whether you're a business owner, contractor, or just someone curious about legal jargon, understanding force majeure can save you from a world of headaches. And that's a wrap. If you found this video helpful, don't forget to like, subscribe, and hit that notification bell for more legal insights. Until next time, stay informed and empowered. Thanks for watching.